Hello and Namaste. My name is Ketan Kank. Welcome back to the question and answer series. The questions in front of me today are: what is the procedure to obtain duplicate share certificates? So, whenever a person has lost original share certificate, the law entails or he has to follow the procedure for obtaining duplicate share certificates. But in today's era, duplicate share certificates are not issued because the share certificates are destroyed and the shares are converted into dematerialized format. So duplicate share certificates are not issued, but the investor has to follow the procedure for obtaining duplicate share certificates. Now the question arises, if the duplicate share certificates are not issued, why to follow the procedure of duplicate share certificate? See, there are two parts to it. Issuance of duplicate share certificates has been stopped because of dematerialization, but the fact has to be established that the original share certificates are not present. So if we take care or if we reflect on the later part of this issue, then the fact has to be established that the original share certificates are not present or lost. So first of all, if the share certificates are being stolen or lost or done anything, then an FIR has to be filed. For filing of the FIR, and we have gone into the details of that procedure in our earlier videos. You can go through the earlier videos and you can see how the FIR has to be filed, how it can be filed online and etc. Then there is a form called as ISR 4. ISR 4 is a multi-purpose form. There are 8 to 10 utilities of that form. One of the utilities is to apply for the duplicate share certificates. So the investor has to fill in form ISR 4 and apply for the duplicate share certificate. Along with Form ISR 4, an affidavit and an indemnity bond has to be executed. Affidavit and indemnity bond has to be executed on the requisite stamp duty by paying the requisite stamp duty on stamp paper. Again, the stamp duty is a state subjective list. So the stamp duty, the amount of stamp duty will vary from state to state, but in order to obtain or in order to follow the procedure of obtaining duplicate share certificates from ISR 4, affidavit in form A and indemnity bond in form B, along with the FIR, has to be submitted to the RTA, and RTA will then process those documents, and after the verification of all documents, if the RTA is satisfied, then the RTA will mark the share certificates are not present and will do the needful, either by issuing the letter of confirmation or the entitlement letter or any other document which he deems fit, and then it can be said that the procedure for obtaining duplicate share certificates has been completed, because in case of the IPF cases, if the shares are gone to IPF, the investor can take that letter of entitlement and fill form IPF 5, or in case the shares are in company suspense account, the RTA or the nodal officer will issue the letter of confirmation, and that letter of confirmation has to be submitted to the depository participant, and within 120 days, and the depository participant will credit the shares or will give the shares in the form of credit to the demat account. Now, holding of a share certificate, as in prior to dematerialization era, holding of the share certificate was evidence enough that a particular person was the owner of that share. In today's era, reflecting of the shares in the demat account is the evidence of holding the shares. Now, if the after following the procedure for issuance of duplicate share certificates, the RTA and the company will credit the shares to the demat account of that investors, and that's how the procedure gets complete. Next question is, I have to remove my father's name from the share certificates as he is no more alive. What to do? See, we presume that the investor in this case is a joint holder with his father, or else the investor would have not written that he has to remove the father's name, because there has to be at least one name present on the share certificates. So if the investor, who for the purpose of convenience we will call Mr. X, Mr. X is the joint holder with his father, then there is a procedure for transposition of the names. If your father is the first holder of the shares in the share certificate, then an application has to be made for transposition of the name. Again, there are three things: transfer of shares, transmission of shares, and transposition of shares. Transfer is between two alive persons. Transmission is by operation of law. When one of the shareholders dies or expires, then his shares get transmitted to the legal heirs. And transposition is when you change the sequence of names on the share certificates or on the records of the company. In this case, if the shares are held jointly by two persons and if the sequence of the names have to be changed or one of the shareholder dies, then the name has to be removed and the sequence has to be changed, then this will fall strictly under the procedure of transposition of names on the company's records, and one has to follow that procedure. There is a separate form for transposition of shares, and that form has to be filled along with the relevant evidence. If the one of the shareholder is deceased, that death certificate has to be submitted. And if transposition of the names is between two persons alive, then the no objection certificate on an affidavit has to be submitted to the company and RTA, and then the company and RTA will do the requisite formalities of changing the sequence of the names. So that is how you can get your father's name removed on this, or for that matter any of the person who is the shareholder's name with the consent of that person if he is alive, and if the person is deceased, then by submitting the death certificate of that person, transposition of the names can be done. If you have any query relating to the shares or reclaiming of the shares or reclaiming of your investments, you can feel free to reach out to us. You may reach out to us by marking your queries, questions in the comment section of this video, or you can also write an email to us. We will be all the more happy to help. Thank you so much.